Hi, I'm Martin Pritikin, the Dean of Concord Law School at Purdue Global, the nation's first fully online law school. Welcome to this latest installment in our distinguished speaker webinar series titled The Battle Over Religious Liberty in the Courts. There's perhaps no one in the country better qualified to discuss this topic than our guest today, Mark Rienzi. Mark is the president and CEO of the Becket Fund for Religious Liberty, one of the most prominent organizations in the country focused on issues of religious freedom. In addition to that more than full-time job, Mark is professor of law and co-director of the Center for Religious Liberty at the Catholic University of America in Washington, D.C. His academic writing focuses on the First and 14th Amendments and has appeared in a variety of prestigious journals, including the Harvard Law Review. He is a widely sought-after speaker on constitutional issues, particularly concerning abortion and the First Amendment. And he's been invited to discuss these issues at places like Harvard Law School, Columbia Law School, Georgetown Law Center, Boston College Law School, Notre Dame Law School, the National Press Club, and the U.S. Capitol. Mark has represented the winning parties in a variety of Supreme Court First Amendment cases, including Hobby Lobby, Little Sisters, Wheaton College, and Holt. In 2014, he argued before the Supreme Court in McCullen versus Coakley, a First Amendment challenge to a Massachusetts speech restriction outside of abortion clinics, in which the justices ruled in favor of his clients 9-0. Mark also led a successful 8-year litigation battle against Illinois Governor, it's a tough one to say, Blagojevich's efforts to force religious pharmacists to distribute the morning after pill and week after pills. Now, prior to joining Becket, Mark served as counsel for the litigation department and the intellectual property litigation practice group for WilmerHale LLP. His practice focused on complex civil and appellate litigation, with a particular emphasis on intellectual property and First Amendment issues. Prior to joining WilmerHale, he served as law clerk to the Honorable Stephen F. Williams, senior circuit judge for the U.S. Court of Appeals for the D.C. Circuit. Mark is a graduate of Princeton University and Harvard Law School, and he was an editor of the Harvard Law Review. In fact, they've run out of prestigious awards and accolades to give Mark, so they're going to have to go back to the factory and invent some more. So Mark, thank you so much for being here today. We really appreciate your time.
Happy to do it.
Now, before we get started, I want to remind those of you who are in the audience that you should feel free to post questions in the comment box. And as we go, I'll try and weave in some of those questions in the discussion, or at least save time for them at the end. So Mark, I want to start off because, you know, could have a lot of people in the audience, a lot of different beliefs. Not everyone's necessarily religious. So let me start off by asking, if someone isn't religious, why should they care about the issue of religious liberty?
Yeah, it's a great question, and thanks for having me on, and thanks for starting with that good one. Look, religious liberty is really, to me, just a part of how do we deal with living in a pluralistic society with people who have different beliefs from the ones we have. You know, my religious beliefs may not be someone else's, and so forth. Religious liberty is really about, do we leave room for people to live out their own set of beliefs, whatever that happens to be? Or do we bring the power of government to bear to force them to change or force them to violate their beliefs? And I think it's really important, if you have an actual commitment to liberalism, if you have an actual commitment to pluralism, then I think you have to have a commitment to religious liberty, because you have to say, well, even if I'm not religious or I don't share a particular religious belief, I'd like to live in a place where the government will leave my neighbor alone to live out his or her best understanding of the meaning of life and who they are and who God is and so forth. And so at Becket, we actually defend people of all religious beliefs precisely on the idea that it's not actually about the substance of any one particular view about God. It's about the fact that we ought to live in a liberal society that allows everybody to live out their own view on that, whatever it happens to be.
Well, so let me ask sort of a related question. I think there's a lot of people out there who are very cynical about Supreme Court jurisprudence on religious liberty issues, and they assume that conservative justices are going to vote in favor of religious liberty and liberal justices will not. You're a constitutional law expert. In your understanding, does history bear out that assertion?
Yeah, no is the short answer. And for sure, folks can be forgiven for assuming that, judges or justices and governments can act in political ways, because sometimes that's true. If you look at the religious liberty cases, it's not true. Actually, the religious liberty cases, particularly over the past dozen years or so, when the courts decided a lot, there are actually a lot of them that are 9-0 or 7-2 decisions. A lot of ones that on paper you might think, well, that'll split the liberals and conservatives in a very particular way, end up not splitting them in predictable political lines ways. So there's actually been a lot of decisions over the past dozen years or so where the justices find quite a bit of agreement on protecting the principle of religious liberty, even when you know or strongly suspect that the justices don't all agree on the underlying issues.
Right. Well, okay, again, I'm going to continue to play devil's advocate, right? What if you have someone who says, look, that's all well and good, but the First Amendment was written in the late 1700s at a time where, almost everyone involved in government was white, they were male, virtually everyone was a Protestant Christian, and we have a much more pluralistic society now where, you have people who are LGBTQIA, right, versus heterosexuals. And now sometimes we have a clash of interests that just didn't exist at the time the First Amendment was written. What would you say to that?
Yeah, I'd say that pluralistic world is precisely why we all ought to be really happy that we've got a good, strong First Amendment. And I guess I would also say that, it's with hindsight, you can sometimes look back and say, oh, all the people of the founding generation were the same or almost the same because they were mostly Protestant Christians with a smattering of Catholics and Jews and not much else. But the truth is they were coming from a Europe in which people were killing each other and taking over governments over these kinds of religious differences. And they made a relatively early decision, which has been like imperfectly carried out for sure, but a relatively early decision that instead of fighting over whether our government is going to be a Catholic government or a Protestant government or a Calvinist government or a Puritan government, instead, we decided that we're going to find ways to live in peace amidst those deep differences. And I think what our First Amendment reflects, the religion clauses, but also the rest of it, is a pretty laudable commitment to say we're going to be able to have neighbors who have real disagreements with us about really important things. And for the most part, we're going to leave them room to live out their lives the way they see fit without bringing the power of government to bear to kick them out of their jobs or make them ineligible to participate in civil society, the kind of stuff that governments in Europe were doing to Protestants or Catholics, depending on which government had control. We made it an early commitment we wouldn't do that, and that's a good thing. And I actually think that commitment to pluralism maps really well and is arguably more needed than ever for our current world.
All right. Well, so you have a perspective on the history of Supreme Court jurisprudence on this. And you focus on the different ways that the Supreme Court has treated religious liberty on the one hand with other fundamental rights, and it goes back a century or more. Can you talk a bit about that in terms of sort of the key landmark cases, Gobitis and Barnett, and how you think the Supreme Court's jurisprudence on this has shifted over time?
Sure. I think when we think about individual rights and pluralism, it often makes sense to go back to some of the early modern cases, the Jehovah's Witness flag salute cases from the 1940s, because those are cases in which the government was saying to Jehovah's Witnesses, who are a minority religious group, that your children must salute the American flag. And if they don't salute the American flag, we will punish them. We will punish the parents. There'll be serious trouble if they don't go along with what the majority thinks. In the first iteration of that case, a case called Minersville School District versus Gobitis, which is rarely taught in law school these days, but honestly, I think still should be taught. In Gobitis, the court said, look, we understand that your religious belief that you can't salute the flag is important to you, and we think religion matters, but the majority has decided that the best way to get children to be patriotic, the best way to stoke nationalist feelings, is to force the children to say the pledge every day. So even though you've got First Amendment rights, we're going to authorize the school districts to force you to put your hand up. Back then, it was more of like a Heil Hitler type salute. We're going to force you to put your hand up and do that salute because the majority thinks we should. Well, that was a terrible decision. It got the First Amendment completely wrong. It actually led to an awful lot of very nasty violence against Jehovah's Witnesses that a lot of people thought was downright sanctioned by the Supreme Court. The ACLU, Eleanor Roosevelt, a lot of people called this out as really bad. And a few years later, the court got it right in what is really, in some ways, the lead modern First Amendment case, which is West Virginia versus Barnett. And in Barnett, the court got it right, which is they said, look, under the Constitution and under the First Amendment, the government can't prescribe what shall be orthodox, and they can't tell you what the right answers are to the big questions. And that means that at least most of the time, people get to believe and profess and live out their beliefs as they see fit, and that those constitutional guarantees are important for the courts to enforce and protect those rights, even as against a majority that thinks nationalism requires something else or some other value is more important.
And so once the Barnett opinion came down, does that mean that go-bitis was dead and it was never an issue anymore?
Well, mostly, except not for religious liberty, unfortunately. So for the most part, Barnett is one of those cases that everybody left, right, and center, I think, usually applauds for. Certainly, all 9 justices on the court today, I'm quite confident, think Barnett is a great decision. And generally speaking, Barnett is the way we approach fundamental rights, which is we say, if something's a really important right, the government's got to have a very strong reason before it can force you to violate it, right? It puts a strong thumb on the scale that it can't just be that the majority thinks otherwise, but we need a very strong reason to let the government violate that right.
That's what's known as strict scrutiny, right?
Yeah, and we all usually call that strict scrutiny. I forgot I'm on a law school webinar, so I can use words like strict scrutiny.
Not everyone may be a law student or a lawyer, but I just want to, connect the dots there. Yeah, thank you.
Great, like the legal test is called strict scrutiny, and it's that the government needs to have a compellingly important interest, and this really has to be the only way the government can enforce its interest. So if I say my religious belief is I need to drive the wrong way on the highway on the way home tonight, or I need to sacrifice a child to Moloch, I'm going to lose those cases, and I should lose those cases, right? Because the government has a compelling interest in saving the child from being sacrificed or saving the people I crash into on the highway. And really, the only way for the government to advance that interest is to stop me, right? It's not like I can just go peacefully practice my religion someplace. They have to stop me from doing those things. And so this doesn't mean religion always wins, just like speech or something else doesn't always win, but it means that the government needs a very good reason to restrain it. That really is the way we do most individual rights in this country, but not religious exercise, at least, not according to the 1990s decision in Employment Division versus Smith, which I think, Justice Scalia decided the case, and people have different views on different aspects of Scalia's jurisprudence, but I'll just say in this one, I think he got it totally wrong, because he said free exercise really gets low protection. As long as the government's enforcing the same rule against everybody, you're out of luck if it happens to restrict your religious exercise. And so religious exercise for a while was kind of the one outlier, the one thing that didn't get the Barnett treatment and got more of the go-bitist as long as the majority likes it treatment. That was a problem. That's a lot of what I actually think the court has been in the business of repairing over the past dozen or so years. And again, it's something that the justices left, right, and center have been part of the process of correcting that.
So let's talk about this. So post-Smith, let's talk about how the jurisprudence has changed. Obviously, there are a lot of cases, but some important ones, in particular, Hosanna Tabor. What was at issue in that case, and how did the court rule?
Yeah, Hosanna Tabor was a case about something called the ministerial exception. So it was a disability discrimination case where someone who was a 4th grade teacher at a Lutheran religious school sued her school. And she said, you fired me because I had narcolepsy. So you fired me for my disability. And so that violated the ADA. What the church said was, we didn't fire you for that. We fired you because you violated our religious teachings, and because we can't have somebody in the role of being a teacher of religion to the children if they don't follow the congregation's religious teachings. And so this was decided in 2012. So, 20 some years after Smith. And the court actually never had to apply Smith, or rarely had to apply Smith in those intervening decades for a lot of reasons. But one of the chief ones was that at the federal level, we enacted the Religious Freedom Restoration Act, which gives really strong protection to religious exercise as a statutory matter, so that the Supreme Court never really had to deal with, well, what does Smith mean and how are we going to apply it at the Supreme Court in future cases? They were sort of spared that for a generation. But in Hosanna Tabor, they were back to a law, the Americans with Disabilities Act, that seems to apply broadly to everybody. And so you would think the government wins if it's a general law. But the court actually decided 9-0 under the First Amendment that the government couldn't tell the church who to hire to teach religion to the children, even if it looks like some other kind of discrimination. What the court said was under both the Free Exercise Clause and the Establishment Clause, the government can't be in the business of telling you who the minister is. They cannot tell you this is the person who should be in front of the room teaching the children. The government's not qualified to judge whether this reason or that reason was the right reason or a wrong reason or a pretext or not a pretext. The court just said governments have to be out of regulating that employment relationship. And one of the things that was really noteworthy about Hosanna Tabor, it was a 9-0 decision, right? This is something Justice Ginsburg, I don't know which one's right and left on your screen, Justice Ginsburg and Justice Scalia and everybody in between agreed upon, was that under the First Amendment, the government just can't do this, even though the Americans with Disabilities Act is a broadly applicable law. And to me, Hosanna Tabor then becomes the start of a sequence over the decade since then of the court really getting back to stronger protections for religious liberty and recognizing that we need those if we're going to be in a peaceful, pluralistic place.
And so it is surprising, right, when you hear that justices like Ginsburg approved this. I mean, you would have thought that they would have ruled and said, or at least the minority, right, would have said, look, if it turns out it's not a pretext, if it really is based on a sincerely held religious belief and a sincere dispute about religious dogma, then obviously do what you're going to do, right? But if it turns out that that's a pretext, then it should be upheld. But even Justice Ginsburg and the other liberal justices said, we're not even going to go there. That's really surprising.
Well, it is in some ways, and it's not. Well, I mean, it may have been surprising, but here's why it's just the right rule. If the question is, why did someone get fired from Walmart or some other secular business, judges and juries are qualified to look at the asserted reasons and do some thinking and say, well, that sounds like you really fired him because he was Jewish, right? Like they can look at that and they can look at the pretext, and secular juries and secular judges are competent to say, I think that's a baloney reason and I don't really think that's true. But they're not really qualified, and it's not really fair to have government entities in the business of looking at the synagogue or looking at the church and saying, well, you say you fired him because you didn't like the sermon, or you say you fired him for this other religious reason, but I don't really believe you. Well, that's pretty tough for the government to do. And I think it's quite laudable that the justices across the spectrum recognize that, like, that's just it's not a place the government's allowed to have a role.
Okay, no, actually, I do think that makes some sense. What about Espinoza? There's been a ton of Supreme Court jurisprudence about the First Amendment Establishment Clause as it pertains to schools and providing funding. What was at stake in Espinoza, and how did the court rule there?
Yeah, the Espinoza case, and actually Espinoza is kind of the middle of a trilogy with Trinity Lutheran, Espinoza, and then Carson. So maybe I can just talk about the trio. These are all cases that arose under state laws that are sometimes called Blaine amendments. And these are laws that were enacted, we got very close to a federal constitutional amendment in the mid-1800s, sponsored by Senator James Blaine from Maine. So they're called Blaine amendments. And they were at a time where there was a lot of poor Catholic immigrants coming in from Europe. And they weren't terribly popular with the, generally speaking, Protestant majority in all the places they were coming in. And we sometimes think the schools used to be, all secular. Well, like, the truth is, back then, the public schools were quite religious, and they taught Protestant religious values, and they read from the King James Bible. And they thought that part of the goal was to Protestantize and Americanize, and they thought those two things were synonymous, Protestantize and Americanize the kids. And the Catholic immigrants, when they got there, said, wait, I disagree with you on that stuff, and I don't want my kid being raised with a Protestant Bible and so forth. And so the Catholics pretty early on began separating off and setting up their own school systems. The Blaine amendments were designed to make sure that government money kept flowing to the Protestant-friendly schools and could never flow to the, they said sectarian schools, which is at the time was essentially code for Catholic. So that failed at the federal level, but for a while, Congress insisted on states putting it in their state constitutions. And so we have a lot of states across the country that have these provisions in their state constitution that do things that on the surface, I think we'd all agree are kind of dumb, right? So the Trinity Lutheran case is a case about a tire recycling program. We're going to use the rubber from recycled tires to generate stuff to put on the floor of playgrounds. So when little Johnny falls, he doesn't scrape his knee. And Missouri had a program where they said, look, if you're a nonprofit in the state and you want to put in an application to get some of this stuff to cover your playground so kids don't get hurt, come on, apply. But they looked at their Blaine Amendment and they said, well, unless you're religious. If you're religious, you can't apply. And the Supreme Court had no difficulty saying in Trinity Lutheran, you've got it all wrong. These Blaine Amendments that tell the religious people you can't participate on equal terms with everybody else, they've got it wrong. In fact, with the free exercise clause, the government must allow religious groups to participate on equal terms with everybody else. And so whether it's, recycled scrap tire for your playground, or a school voucher program, or a school tax credit program, which is at issue in Espinoza and something like that in Carson, if the government's going to make it available to private schools, it can't say private schools unless they're religious, right? The First Amendment doesn't let the government say to religious people and religious groups, you're second-class citizens, you can't participate in the same way as everybody else. So over that range of cases, the court, again, with broad majorities that included some liberal justices, made clear that that's not the way the First Amendment works, and you don't just get to exclude the religious people and groups because they're religious, they get to participate too.
Well, let me push back a little bit because on its face, doesn't it appear that there's a conflict between the free exercise clause on the one hand and the establishment clause on the other, right? Because if the government is going to make a benefit or a program available, on the one hand, you're saying, well, if you're religious, you shouldn't be treated as a second-class citizen, you shouldn't be able to participate. However, if the government's providing a benefit to a religious school, let's say, then isn't there an argument that the government is sort of endorsing or promoting religion by providing funding or services for that religious education?
Yeah, that's certainly an argument that's made. I think it rests on a misunderstanding of the establishment clause, right? And the court has done a good job in recent years at getting away from that too. But if you view anything the government does that touches religion as, oh, the government must be telling us to be that religion, and the government must be establishing that religion, then you could say, okay, well, then if some money goes even to the playground, right? The kids might say a prayer on the playground before they play. You could say anything like that is the government endorsing religion. There's a couple things wrong with that, but here's the most obvious one. They're just obviously not establishing a religion when they put recycled tires down on the playground, right? Or, one of the cases was about, a town that had prayer before the meetings, and one was from a Wiccan priestess, and one was from, I don't know who else, but like that town didn't become a Wiccan town the day that person said that prayer, and nobody thought that, right? And when New York tried to have special rules for Orthodox Jews in upstate New York to get social services at their schools, no one really thinks New York State became an Orthodox Jewish state either. So it has to do with a misunderstanding or an overstating of what it means to establish a religion. The truth is the people who wrote the Establishment Clause had a real thing in mind, right? They actually knew what an established church looked like. It wasn't just anything that touches religion. It was, there is an official government religion. We will write the prayer books. We will pay the ministers. We will require you to take communion here once a year, or we won't let you do things like foster children or serve in government, which is what England did to keep people with the wrong religious beliefs out of government. So there are all these things that are the real hallmarks of establishments, but they're not like any of these cases. And the court has actually done quite a good job saying Establishment Clause is real and it means something, but it doesn't mean anything that touches religion is bad. And it certainly doesn't mean we get to kick religion out of public spaces, which unfortunately is how it's been understood too often these days.
Well, so how does Fulton versus Philadelphia fit into this framework? That was decided just a couple of years ago.
Yeah.
How does that lay into the spectrum?
Yeah, and so Fulton, and I should say, just as disclaimer, a lot of these cases are cases I worked on. A lot of these cases are cases Becket had clients in. Fulton was a case about Philadelphia's foster care system, and the Catholic agency in Philadelphia, who had been doing foster care for a couple of centuries, right? Before the government was involved in foster care in Philadelphia, the Catholic Church was doing foster care in Philadelphia. And it had a long, great record of doing it, until a reporter called up and said, well, what would you do if somebody applied to be a foster parent with you and they were in a same-sex relationship, or they were in an unmarried opposite-sex relationship. And unsurprisingly, the Catholic Church has religious beliefs about sex and marriage. And the person at Catholic Charities said, well, we wouldn't be able to do the home study and say, we think this is a good place to put children. But we also wouldn't want to come in and ding you and reject you. So what we would do is we would just refer you to the other 30 agencies in the city who'd happily work with you. Here's a good fact about America. This is always one that gives me hope. The gays and the Catholics in Philadelphia had apparently long been able to work this out. There had not been any record of any gay couples actually going to Catholic Charities and knocking on the door and saying, I'd like your church to come in and do an evaluation of my home. Because I think the gays and the Catholics knew they've got a disagreement about this. And so gays were fostering in Philadelphia through the other 30 agencies, and it was fine. And the Catholics were taking their Catholic approach, which by the way, includes saying we wouldn't serve opposite sex unmarried couples either, because they think it's better for mom and dad to be married. So that had been going on, but Philadelphia made a big lawsuit about it and said they were going to shut down the agency. And also, in what was frankly a pretty vindictive move, they also wouldn't work with any parents who had previously been certified through that agency. So it wasn't just sort of we cut off that agency, but people who were like former foster parents of the year and had fostered like 40 plus children and been wonderful parents got cut out of the system at this point by Philadelphia saying, nope, if you won't do it our way, you're out. We litigated that all the way to the Supreme Court. And you might have thought, a clash between gay rights and religious liberty at the Supreme Court, how are we ever going to sort, like same-sex marriage and religious foster care out? We can't work that out. The truth is, like, we worked it out pretty easily, 9-0, right? 9-0, the Supreme Court said Philadelphia can, of course, encourage gay couples to foster and can work with all these other agencies that do it. But you can't tell the Catholics that the price of admission is they have to violate their religious beliefs about sex and marriage. They can participate too. And in fact, they've been good participants in the system. And I'm happy with Philadelphia for another reason. After that decision, there was a path through which they could have continued the case. It could have changed something in the contract to try to keeping the Catholics out. And the ACLU could have continued the case as well, because they were part of the case. But to their credit, both of them after that decision, and another 9-0 decision, said, okay, we get it. We're not going to keep fighting that fight. And the result today is there are lots of gay foster parents in Philadelphia. They're continuing to do it. The Catholic Church is also there too. And the truth is there's a ton of foster kids in need, and we really do need all hands on deck. And so coming to a solution that says neither one of you needs to give up the core of who you are, and you can both work together solving this big problem, is, I think, a really good thing. And again, it's another one that you may have thought you'd get a big left-right divide, and instead you got 9-0.
Well, so last year there was Kennedy versus Bremerton School District, which, in light of the cases you discussed, probably should be an easy case, but it got a lot of attention. This was about the high school football coach kneeling and doing a prayer on the field. How did that play out?
Yeah, that one ended up, I believe it was 6-3 in the end. So that one did have your left-right divide. And I think a lot of the disagreement among the justices was over the facts, right? Some of them thought that there was some coercion. Some of them disagreed. I think the majority had it right that the coach was fired, not for anything to do with coercion, but simply for saying the prayer. But I put Kennedy in the basket of the cases about whether the government can exclude religious people and religious groups. The school district said if the coach had taken out his cell phone at the 50-yard line after the game and made a phone call, that would have been fine. If he had greeted his friends or his wife and had a conversation with them at the 50-yard line, that would be fine. In other words, the school said, we're not controlling your speech. We're not controlling what you do there unless you kneel and pray. If you kneel and pray, you're violating our rules and we kick you out and you lose your job. And again, in a world where you can do anything else you want at that spot, you're off the clock, it's after the game. I think it's not the right answer for the government to be kicking people out for their religious exercise. Some people say grace before meals. Some people bow and pray facing Mecca 5 times a day. Some people wear a yarmulke. Some people carry a kirpan. Lots of people have different religious exercises. I actually think it's a terrific result for the court to say to governments, you have to let people who work for the government do those things. Now, it would be different if the coach said, you're not playing on my team unless you say the Lord's Prayer. That really would be a problem of government coercion. The majority said that wasn't this case. There wasn't coercion. It was after the game, and therefore he couldn't be punished for it.
And so we've talked about some recent decisions. Let's talk about cases that are currently pending and should be decided literally within days, right? Supreme Court usually hands down their
It's that season
by the end of June, and sometimes they save the blockbusters for last. A real potential blockbuster is 303 Creative LLC versus Lennis. What's at stake in that case?
Yeah, this is, you could think of this as the Cake Baker 2.0. So if you remember 6 years ago now, the case was called Masterpiece Cake Shop. And it was also out of Colorado. It was about a baker who didn't want to make a wedding cake for a same-sex wedding. And Colorado said, no, if you make cakes for weddings, you got to make them for a same-sex wedding too. The court in that case, by a 7-2 decision, again, it was not a 5-4 nail biter, but 7-2. And it included, like, for example, Justices Kagan and Breyer siding with the baker in that case. The court said, well, the government seems to have had real hostility to this gentleman's religion. They compared him to Nazis and racists. They didn't give him neutral decision-making. They really targeted him for religious beliefs that they didn't like. And they ruled in favor of the baker. In some ways, the 303 Creative case is a natural follow-on to that because they didn't decide Masterpiece Cake Shop on terribly broad grounds. They said it's because of this government hostility. 303 Creative, and in the Cake Baker case, I should say, we did spend a lot of time talking about, is a cake speech, right? Because one of the questions was, is it a forced speech case if they make you bake a cake to celebrate something that you don't like? Is the cake expressive? And the cake baker said, I think I am expressing something. And the state said, I don't think it's expressive at all. The court ultimately just decided it on religious hostility grounds and didn't get into that. 303 Creative is a case where it's really speech, right? Now we're talking about a website designer who says, I want to create custom wedding websites for people, but I can't do it to celebrate a same-sex marriage because that doesn't fit with my beliefs about marriage and what God wants me to do. And so the question there is, can Colorado use its public accommodations law to force this woman to write up and create a website celebrating something that she thinks she shouldn't celebrate? And in that respect, the case is, I think, a lot easier than the Cake Baker case, because in the Cake Baker case, you could really wrestle through where is the line about what counts as speech. Here, it's absolutely speech. In fact, it's so much speech that when the justices granted cert in the case, the original question presented as written by the lawyers included religious exercise, and they granted solely on speech grounds. And I think that's because under traditional free speech law, the government just can't force you to write speech or give a speech or say words that you don't believe. Like, that's sort of textbook standard free speech law, leave religion aside. Government just doesn't get to do that to you any more than they could make you write a law review article on something you don't like, or some news columnist write a news article they don't like. Like, the government just doesn't get to make people write and say stuff that they don't believe. And so 303 Creative, it ought to be a 9-0 decision. I don't know that it will be, because it's obviously, it's charged, it's culture war charged, so you never know. But on standard speech principles, it really ought to be an easy case. Government just can't make you write words to celebrate something you don't want to do. Just like, they couldn't make an atheist write something good about a Catholic ordination or something like that. Like, you just can't have the government grab people, force them to say things they don't believe.
So, you talked about the culture war, and I guess an interesting question is, the website case, from what you're saying, should be an easy case. It's clearly speech, right? The cake baking case never really got to it. Since you're a law professor and we trade in hypotheticals, right? What about a photographer? Could a photographer say, I don't want to photograph a same-sex wedding because you're forcing me to create images that endorse this? Do you think that would be, they would be allowed not to photograph that type of wedding on religious liberty grounds or First Amendment grounds?
Yeah, and let me give you 2 others to pair with it, right? I'd also pair the atheist photographer who doesn't want to go to the Christian wedding or the Christian baptism, right? Who says, look, I'm not going to make your Christian service look good. I think it's bunk and it's make-believe, right? Or imagine a photographer or, somebody who owns a reception hall saying, I'm not hosting the Trump for president rally at my place, or I'm not photographing Donald Trump. I don't want to make Donald Trump look good. I think he's terrible, right? Like somebody says that. I think in all those cases, our standard way of living with differences and living with different beliefs is to say, of course, the government can't force those people, right? You can't force the atheist to go sing at a religious wedding if she doesn't want to. You can't force the person who doesn't like Donald Trump to host the Trump for President rally. We just don't do those things to each other. Like this is what being a decent person in a society with different opinions is like. And so in all those cases, I would say, sure, the person gets to say, I don't want to do that.
Okay, let me ask another extended hypothetical, and this is going to take a little bit of a dark turn, but I want to see sort of where you think this would fit. So, back in the 1960s, right, when the Civil Rights Acts were passed, you had Supreme Court cases where motels, restaurants, diners, right, they didn't want to serve Black people, right? Yep. And the court basically said, sorry, this isn't just a matter of your private decision as a business, right? This is an issue of interstate commerce. Congress has the authority to regulate interstate commerce. And if that means your private establishment, you can't say, I'm not going to serve Black people, right? What if someone were to say, it's against my religious beliefs for, let's say, I don't believe in interracial marriage, right? And so I'm not going to serve a meal to an interracial couple, or I'm not going to rent a room to an interracial couple. Have cases like that come up, and where do you think that would shake out?
Yeah, so a couple things about the history trip and then the modern. In those cases, which I think came out the right way, the court said it's within Congress's Commerce Clause power to regulate these things. That this is part of interstate commerce, and part of the reason that they said it was part of interstate commerce was they said, look, the impact of the exclusion of Blacks from restaurants and hotels and motels and so forth is a really big, serious impact, right? Black people would travel through the country and have to have special books to find places where they could possibly get served. And the court said that's a big burden, and it's fine for the government to act to remedy that. Now, the hotel owner in Heart of Atlanta Motel and the barbecue owner in Katzenbach, they weren't asserting religious liberty grounds anyway, and I'm not aware of the parallel modern case of somebody saying I won't rent hotel rooms to gay people. And in the cases that we're aware of, at least, like the cake baker in Masterpiece said he'd hire gay workers and said he sells cakes to gay customers. So none of the actual cases that we're talking about are that case. They're all ones where someone says there's a specific thing that I can't celebrate, but it's not that I won't ever serve a group of people. So I'd say the difference between the two sets of cases are, one, there's like a class-based, I exclude the whole class thing going on in the old cases that is simply not happening in the modern cases. And two, Congress is reacting to what was really a full exclusion from the market, as in Blacks couldn't find any hotel room to go to because all the hotels were doing that. And that's why we needed a Civil Rights Act of 1964. I think the government's case is just, a lot stronger in circumstances where they've got that kind of compelling interest. In the cake baker cases, it's a setup, right? Like the reality is, if somebody thinks your marriage is evil, awful, and wrong, you don't really want to give them business to make a cake for your wedding, right? This is a use of public accommodations laws in order to get someone who's got beliefs you don't like. There's no shortage of people who would bake the cake. I think the cake was baked for free by some other place. There's no shortage of florists. There's no shortage of website designers who would happily do it. So you also don't have anything that parallels the exclusion of Blacks from so much of society in the 1960s.
I hear that. Makes sense. Okay, another case that's pending, Graf versus DeJoy. This is the postal worker who refuses to deliver packages on Sunday. How do you think that's going to shake out?
Yeah, so this is interesting. This is part of what I would call the Supreme Court trying to clean up its own house and fix its own old mistakes. So in the 1970s, actually shortly after the 1964 Civil Rights Act, and the 1972 amendments to that act, they made it illegal to discriminate based on religion. And they said that includes in private employment that you have to have reasonable accommodations for your employees' religious exercise. You have to reasonably accommodate your employee unless it's an undue burden on the undue hardship was the term, undue hardship on your employees, on the employer to accommodate the person. So, that language seems to suggest that the employer's got to come forward with some real burden, right? It's got to be a hardship, not just, an annoyance or an inconvenience, but a hardship and an undue hardship, right? Like, some hardships are going to be okay, but maybe some will be undue. wasn't really clear what that meant. The Supreme Court, in a case in the late 70s or early 80s called Hardison, interpreted that phrase very, very narrowly and said basically everything is an undue hardship, which means the employers almost never have to accommodate. It's always an undue hardship if the employer has to incur more than a de minimis cost. So like that was the phrase. Anything that's more than de minimis counts as a hardship and an undue hardship. That was a mistake. There's no way that's what Congress actually meant when they wrote those words. The court wrote that at a time that religious liberty jurisprudence was really a big mess in the 1970s. They were still doing Lemon versus Kurtzman. They were getting a lot of things wrong. They were afraid everything would be an establishment. So they got it really wrong. So fast forward 40 years to today, the Graf case is about a postal worker who signs up for the work of being a postal delivery man at a time when, that's a good job if you don't want to work on Sundays, because we don't do mail on Sundays.
Right.
But what this Mr. de Graf didn't anticipate was that eventually the Postal Service would cut a deal to make some money by running deliveries for Amazon on Sundays. And so the question is, so this guy's got a religious belief that he can't work on Sundays. And is it an undue hardship on the United States Postal Service to get somebody else to deliver the Amazon packages that Sunday instead of him? I think if we give words their normal meaning, that's a pretty easy case. The Postal Service is huge. There's a lot of people who happily work Sundays. He'll work Saturday. I'm sure a lot of people would like their Saturdays off. I don't know what the budget of the post office is, but it's pretty big. I don't know how big the contract is with Amazon, but I bet that's pretty big too. The government could get somebody else to do that job and let the guy work the other 6 days of the week. So in plain English terms, it ought to be an easy case. What I don't know is what the court will do with the test, right? Because they've got this old precedent that said it one way, and I don't know where they'll go. I don't think anyone knows other than the 9 of them where they'll go with what they'd set up for the test. But in practical terms, it seems pretty easy to say Postal Service should be able to get somebody else. Somebody posted in the chat, I see that it was a small shop, and it's true that particular post office was a smaller outpost. But I think if we do it the right way, the way we do the same words for like the American with Disabilities Act, you don't say, well, let's go to the smallest business unit and say, within that unit, do you have somebody? It's more, this is a massive multi-billion-dollar a year enterprise. Can you find a way to work around the guy who's got a Sabbath? The answer to that question is, of course you can. And it's a matter of just spending a little bit more money or cutting a different deal with Amazon or hiring somebody else. But the federal government can obviously do that.
And, you mentioned one of the facts in this case happened to be that he was hired at a time when they weren't delivering on Sundays. So,
it is not my case, so I don't want to say that I'm 1,000% sure of that, but I believe that's true.
I think that's right too. But I assume, based on what you're saying, right, even if someone were applying to the post office now and the post office said, sorry, one of the qualifications for the job is that you got to be able to work on Sunday, I think he could probably say, no, you can get other people to work on Sunday. That's not a reason not to hire me, right?
Absolutely. And our Orthodox Jewish friends and Seventh-day Adventist friends and other folks who have, Friday to Saturday Sabbaths often deal with this, right? And under federal civil rights law, which I think is really laudable, the rule is that the employer is supposed to reasonably accommodate them. Now, if I wanted to be a college football coach, right, but I said my religious beliefs are I can't work on Saturday, well, that really would be an undue hardship because most of the games are on Saturday, right? But most jobs aren't college football. Most jobs you can work around, and certainly postal delivery, you can easily work around some guy who can't deliver on Sunday.
So speaking of Orthodox Judaism, let's talk about YU Pride Alliance versus Yeshiva University.
Sure.
I know there were some sort of procedural machinations there, but what's going on with that case?
Yeah, that's a shocking case in a number of ways. So this is a case brought in New York State Court by a couple of current students, but mostly alumni of Yeshiva University, which is a modern Orthodox university in New York, in which they are objecting to the fact that the rabbis at the university and the administration decided not to have a gay pride alliance, right? They wanted to have a YU Pride Alliance club. And the university said, no, they said, we welcome our gay students. We're not saying we won't serve or don't want gay students, but we're not going to have a pride alliance. We will have programming, we'll do other things, but we're not having that. They sued under New York City public accommodations law. And the trial judge actually found that Yeshiva University was not a religious institution, which if anybody's hanging around in New York or wants to go check it out, I challenge anybody to spend 2 minutes near Yeshiva University and tell me it's not a religious institution. It is as religious as they come. It is a very obviously very, very religious place. The people on campus study Torah for 4 or 5 hours a day. There are separate men's and women's campuses. It is a thoroughly, thoroughly religious place. Not my religion, but it is religious. So the state court decided you're actually not a religious institution at all. You're an educational institution. And they acted like you can only be one or the other, which would shock lots of people, would shock Notre Dame, shock everybody. But a lot of people think you can do both education and religion at the same time. The New York court said, no, you go in this bucket, you're not religious. Therefore, we can force you to approve this club right now. We had some emergency appeals up to the Supreme Court. 4 justices said that when the case comes back, they would grant cert and we would likely win. But they sent it back down and said, you should check one more time to see if in the New York system, this order can be put on hold. And what happened when that happened was the plaintiffs agreed to put the order on hold while the case proceeds. So that case is currently chugging its way through the New York State court system. And either the New York State court system will get the right answer, which is, of course, the government can't force yeshiva, can't tell the rabbis what clubs are okay in their Orthodox university, or we'll go to the Supreme Court, where I would strongly suspect it would be another case where we'd get 8 or 9 votes, because it's actually a pretty clear thing. Of course, yeshiva is religious, and of course, they have the right to decide what clubs they'll have and which ones they won't.
Now, another case involving Orthodox Judaism, it's not a Supreme Court, but it is actually of interest to me. I live in Los Angeles. There's a case that Becket filed a few months back, Loffman versus California Department of Education, where some Orthodox Jewish schools sued because I believe the law, and you can certainly correct me, right, that California will provide funding for services, special education services. Obviously, if you're in public school, they provide those services. If you're in a private school, they'll provide funding for special ed services if it's a non-religious private school, but not if a religious private school. Did I get that right?
You did, except it's federal money that's flowing to California, and then California's tasked with giving it out under the IDEA Act, Individuals with Disability Education Act. And you're right, they're saying you can, normally you could take those funds to a private school if the public school near you couldn't serve your child. But California says if you take it to a private school, it has to be a secular school. It can't be a school in which religion is also taught. And what that does is that puts these parents to a terrible choice of, you can either get the funding to take care of your child's special needs, or pursue a religious education for your child, but you can't do them at the same time. And as a constitutional matter, there's just no reason that California is obligated or allowed to put parents to that choice. The government shouldn't be saying the terms for getting your money are to put your kid in an environment that denies God. It should say, well, if we can take it to private schools, you can take it to all of them and we won't discriminate.
So, regardless of what I would want the outcome to be, I mean, it would seem based on, what we've talked about with that trilogy of cases, right? Trinity Lutheran, Espinoza, Carson, this kind of seems like a no-brainer. How is it that California's even been doing this all along?
Well, there are a lot of states and a lot of state governments and local governments that have things baked into their laws that are based on what I would call the old bad understanding of the Establishment Clause, right? So from the 60s and 70s era understanding, that is just incorrect. And so I think in a lot of ways, a lot of our society baked into its operating procedures, these discriminations against religion, like we got to keep religion out, we got to treat religion worse, and they're just not permissible. And so look, one of two things will happen here. Either California will look at it and say, oh, now that I see, I'm not supposed to be doing that. And by the way, if California gives aid to some families at Orthodox Jewish schools for their disabled children, you'd have to be an idiot to think California established Orthodox Judaism. It did nothing of the kind. It helped a kid who had disabilities where the kid was. That's all it did. And it's silly to say that's an establishment. So either California will come to its senses and realize, oh gosh, we shouldn't be doing that, and we want to help disabled kids. I hope and pray that's the answer they come to, or they're going to lose in court. But one way or the other, they're not going to be able to keep doing this to these families.
Well, so let me play devil's advocate again, even with this case, right? Let's say it's the case that in public school and most, non-religious private schools, they're getting education, math, history, science, right? 7 hours a day. And that's the services they would provide, special ed services. Let's say someone needs a shadow or something, right? 7 hours a day. Let's say in a religious Jewish school, they're in school 12 hours a day, right? 6 hours are secular subjects, 6 hours are religious subjects. Is there a viable constitutional argument that, hey, if we're going to provide special ed services or funding, it's one thing to provide for those 6-7 hours of secular studies, but if you're going to do an extra 4 or 5 hours of religious studies that we wouldn't be paying for, then that really is extra that is going to help you learn those religious subjects, and that is entangling government with religion. What would you say to that argument?
So first, I'd say, Dean Pritikin, you're a good law professor and you're a good devil's advocate. So it's a good question. One, I'd say that is not a description of California's rule. So just to be clear, California's rule is not, let me count the hours and I don't want to pay for too many hours. And here's the problem. Their rule is religion is out, right? So one, that's not the program. If they had a program that said, we'll pay for 8 hours of school, but no more, that would be a completely different question than we'll pay for secular school, but not religious. But beyond that, sure, I don't think it would be impermissible for a state to say we're giving 8 hours of help to every kid. 8 hours of help, and you do what you want with it. I think that would probably be okay. And then secular school, religious school, someone wants to go 9 hours, well, then you've got to pay for hour 9. If you're treating everybody the same, then I don't think you're going to violate the free exercise clause. I think the problem is California's not treating everybody the same. And if tomorrow they watch your webinar and they change the law to say what you just said, I will immediately amend the complaint to say, well, it's also not okay if you come up with your hours thing because you're looking for a sneaky way to keep the religious people out, right. Which frankly, if they come up with that system tomorrow, is precisely what they'd be doing. Again, my general view is I don't think people are evil. I don't think California's administrators are bad people. So I actually doubt they would sit down and say, let me scheme up my way to keep the religion people out. I really hope they wouldn't do that. I like to think better of people. So my suspicion is they're going to defend the rule they wrote, and that's not constitutional. So they'll either change their mind on it or they'll lose.
Okay. And are there any sort of hot button religious liberty issues that you see coming down the pike that are going to be litigated either in front of the Supreme Court or big issues in front of other courts?
Sure. I mean, there's a lot. There are medical conscience issues, right? So, whether some person should be involved in assisted suicide or sex change operations or abortion against their will. Or in Colorado, we've got a case about a Catholic healthcare provider who, if someone's taken the first abortion pill and changes her mind, gives her progesterone, which helps her keep the baby. And Colorado's actually tried to make that illegal. Well, like the Catholic entity is saying, well, I have a religious obligation. The person's in front of me and says, I don't want my baby to die. Can you help me? I've got a religious obligation to help her. So there's a lot of medical conscience issues coming up. There'll be a lot of fights about schools. The short answer is, yeah, there's an awful lot in a lot of places.
So obviously a very hot button issue is abortion. And I know that your organization is focused on religious liberty, not abortion per se, but obviously there's potential overlap there, right? And actually this sort of touches on one of the questions that from the audience. So, is there an argument that when you have state legislatures that pass abortion bans, really what they're doing is they're trying to impose a majoritarian religious view, and they're actually violating the religious liberty of those who either don't subscribe to that or are non-religious? I know that's a big one to throw at you 7 minutes before we're wrapping up, but do you have something you could say on that?
Yeah, it's a bad argument, right? It's a bad argument to say, well, because this view coincides with some religious belief, the government's not allowed to pursue it. I mean, the truth is that life begins at birth, which was our constitutional rule until a year ago, right? That coincided with a lot of other people's religious beliefs, but no one said that was an establishment of religion. The rule that you can't murder coincides with my religious beliefs and other people's too. So no, you don't get to just look at a law and say, oh, that matches somebody's religious beliefs, therefore it violates religion. There have been some cases where people say, I have a religious belief that I must abort. Those cases are, I think, very likely to lose on any number of grounds. But theoretically, you could imagine someone who has a sincere religious belief in a very particular situation that they need to get an abortion, right? It's at least theoretically possible. There's some old Jewish texts that talk about that. We've actually never had the case. We've never had the case where someone comes in actually in that situation. But there have been some recent cases where people raise the possibility that in some future time, they might be in that situation as an attack on an abortion ban. I don't think that's likely to be a winning argument for a few reasons. One, at most, I mean, the way religious liberty works, at most, that would get you an exception to the law. right? So like the most that would do would be to give you an exception in this really, really rare case, which is usually when the mother's life is in danger. Well, the truth is most of our abortion bans already have an exception for that. So it's not likely that abortion would be banned, but at most it would get an exception for a certain circumstance as opposed to tear down the whole law. But then secondly, at most you might be able to get a court to go to strict scrutiny, but I actually think the governments would have a very strong case to say, well, we do have a compelling interest in saving the life of the child. We think that's a human being and we don't think you should be able to kill it. And the only way we can protect that baby is to protect that baby. So those cases are out there. They're starting to percolate. I'll note that none of them happened pre-Dobbs, which is a bit of a tell that they may not be sincere claims, because if they were sincere claims, you would have thought you'd see these claims before Dobbs, because lots of abortions were illegal then too. If they were sincere claims, you would have thought you'd see them in Europe at some point, because Europe restricts abortion more than we do, but no record of them there. But ultimately, I just don't think the claims are likely to get very far.
So it touches on an idea, and it sort of relates to a couple of the audience questions as well. How often has it been litigated, or how often do you come across cases where there's arguably a specious claim that something is a religious belief,
Yeah.
And I'm thinking about, there was litigation with the Church of Scientology, I believe back in the 70s and 80s, as to whether they were actually a legitimate religious organization such that they could claim tax exempt status. How often does that come up?
But it depends on the context. It comes up often in prisons. It came up a lot during the Vietnam War. It comes up from time to time, right? Because some people will look at the world and say, I'm motivated to have my belief and state it in religious terms because I think there's something I can get, right? So again, Vietnam War, right? People will have a strong motivation to fake a religious belief because they don't want to go get shot and killed. Prison, people will sometimes fake a religious belief if they think they can get better treatment, right? So there's some church in Kansas, some prison in Kansas where the inmates, with really creative thinking said, we're part of the Church of the New Song, and our sacrament is we have to have Chateaubriand and really good wine for dinner every night. Well, the court said that's not sincere, right? Courts can look at that and they can judge your beliefs to be not sincere. You don't usually see that in a case like the Little Sisters of the Poor case or Hobby Lobby or the Cake Baker, because the truth is none of those parties are really getting something out of the religious belief. Like they are, look, if the guy had no religious beliefs, he'd bake the cake because he'd make $100, right? Like there's no incentive for him to fake it. So right. You get these cases where sincerity becomes an issue, I think, where you see a strong incentive to fake it, where there's strong secular reasons someone might fake it. And then courts do what courts do in everyday bread and butter cases, which is they do look to see, not is this religious belief true, but is it truly held, right? Do I think the person in front of me really believes the thing they're saying? And courts can't judge the truth of whether Jesus was the Son of God or whether God wants you to take Saturday or Sunday off. They can't judge the truth of God or what God wants, but they can judge whether the human being in front of them is telling the truth or lying, which again, they do all the time in every hit and run accident case.
Right. Well, we only have about a minute left, so I want to give you the last word. And really, it could be anything you would like the audience to know, a perspective on religious liberty, a perspective on the jurisprudence, sort of what's your sort of big takeaway you would like people to have about this?
Well, thanks, Marty. Thanks for having me on. It's fun stuff to talk about. I hope people have enjoyed it. The thing I would say is this, is religious liberty is really just part of living in a pluralistic place and leaving room for people who have different beliefs than you have, different beliefs than I have. And most of the time in a decent society, the best thing to do is really to live and let live and to let your neighbor live out a different belief than you have. And I think that's good. And I think that's what our religious liberty cases have been saying over the past decade. And I'm really glad and optimistic for my country at a time we got a lot of division and a lot of polarization, that the court, left, right, and center, has been leading in this direction of saying, this is how we live together in peace, and it's a good thing. And there's actually room for everybody. And so, we could all use a little bit more getting along these days.
We sure could. It's definitely a very polarized time. And I think people often state or view things in terms of irreconcilable opposites. But it's great to hear a perspective that it doesn't have to be that way, right? That instead of a culture war, it could be a culture peace. So hopefully we can get that, and hopefully the court can help. Well, that's all the time we have. I want to thank you so much again, Mark, for taking your time to talk with us. I thought it was a great, fascinating discussion. Thanks to all the audience who tuned in. Thanks for those of you behind the scenes who made this happen technologically and otherwise. And take care, everybody, and look forward to talking to you the next one. Have a good day.